No, so I think that the Chief Justice, from my reading of what he's said about particularly the Electoral Commission, admitting that there were serious constitutional and administrative breaches, okay, but in his view, on the face of it, does not warrant the finding.
He didn't say breaches, questions.
Questions. He said
serious constitutional and administrative questions.
Okay.
But they do not, on their face, and prima facie is on the face. Yeah. They do not on their face meet the threshold required for a prima facie determination.
So that clearly, he acknowledges that there could be questions. So that's why I said, I would have said that, well, if I were Chief Justice, I'm not. I would have said, well, because of the serious constitutional and administrative questions, on the face of it, I've seen that. So you have to come to try to explain.
He doesn't stop there. He says that the petition largely rests on conclusions of unlawfulness and bad faith without establishing at a preliminary level. They didn't establish at a preliminary level. Clear facts demonstrating intentional wrongdoing or a manifest inability to perform constitutional functions.
So if there is a constitutional question which manifests itself in the form of a breach, does intention matter? If the Electoral Commissioner feels, neglects, or refuses to file his properties with the Auditor General, does his intention to file at a later date matter? Does it matter? It's a question, it's a constitutional question. And in your view, it's a breach. And that breach must have consequences. So that's how I see it. That's how I see it. And then he introduced another thing that clearly puts us on a journey to discovery. Because he says, in his view, it does not meet the threshold. What's the threshold?
He says you are talking about conclusions of unlawfulness and bad faith without establishing at the very face, preliminary level, clear facts that demonstrate intentional wrongdoing or a manifest inability to perform constitutional functions.
So
even if the Commission's actions or inactions are assumed to be erroneous, controversial, or suboptimal, such shortcomings do not automatically translate into stated misbehavior or incompetence within the constitutional sense.
So I'm looking at it in terms of incompetence, particularly with SAL. So what clear facts do you need for SAL? The people exist. They are by law to be represented in Parliament. An election was conducted. These people were not represented in Parliament. Their inability to be represented in Parliament is because the Electoral Commission failed to create a constituency.
That's the question. Is that the fact?
That's the fact.
Okay.
It's a fact.
Electoral Commission failed to create.
To create.
Willingly.
No, I'm not bringing, I'm not qualified. I'm not
That's
qualifying.
The question he's asking you.
So I'm not qualified.
Were they intervening facts? Were they court situations? Were they Parliament's job?
I'm not looking at the facts. So I'm not looking at the subjective. That is, why didn't they do it? I'm looking at the objective. I see a people. The Constitution says that every person in Ghana has to be represented. And that's why we divided the country into constituencies. And I see, as a matter of fact, a manifestation of an inability by a commission to get people to be represented. I also see from the Constitution, Article 97 or so, that the representation is taken seriously by the constitutional drafters, that if you are an MP and you fail to be in Parliament for 21 certain days, you have no excuse before the Privileges Committee, your seat will be declared vacant. I see that too. So I take representation from the reading of the Constitution very seriously. And I see these people were not represented. And so I see it. They're facts. I see it. I don't know whether it was intentional or it was inadvertence or it was just by operation of circumstances beyond their control. I don't know that. But I know the facts are this. So I expected when if I put in a petition to say that these people were incompetent, and you see that they were constitutional and administrative questions on the face of the petition, the least I expected was to tell them to come and like the Ashanti say, oh, you know, to come and tell me, to come and tell the committee, come tell us exactly what happened. That Trophy, Akpafo, Lolobi, and Lipe were not part of Parliament. If they come and they discharge that responsibility, I say, well, we cannot, that was not incompetence on their part. But if I say that on the face of it, what facts again do I need to establish on the face of it? And that's why I'm saying that the only reason why I say that the decision is a decision that seeks to establish institutions of governance is I see Bafo Bone as an institutionalist. From this judge, finding, I see him more directed towards creating powerful governance institutions for this country and making sure that people who occupy those institutions are not subjected to the whims and caprices of other Ghanaians to make them very unstable. That's how I see it. But there are serious issues with it. Now, the second issue I have with it is consistency is a virtue in jurisprudence. And that's why we have precedent. Never mind that he didn't set the first precedent. But it's a precedent in our electoral practice and constitutional practice. That once upon a time, breaches of an act of parliament, the Procurement Act of Parliament, was held to be enough to meet the threshold of Article 146(1) of the Constitution. Incompetence. Now, today, by the judgment of, or by the decision of Justice Bafo Bone, it appears to me that that threshold was a lower threshold. And probably, if Justice Bafo Bone were sitting at that time as a Chief Justice, Charlotte Osei would not have gone home. Because again, institutionally, we would have protected that institution. And particularly when the threshold, his threshold, is not breaches of statute.